a university was using skin color, or for that matter, gender, to help or hurt people. So I filed my lawsuit. I was in Washington the day that we filed. No one could have prepared me for even that day. My first interview was with the New York Times. Here I was, a shy girl, sitting around a big conference table in a law firm, talking with a reporter from the New York Times, and they're sending photographers in, and it was shocking, to say the least. I got home from Washington, and there was media camped out on my parents' front lawn. Luckily, my dad, being a police officer, he took care of that for me. But I mean, that was the type of situation that I was all of a sudden in, without even, because I was standing up for what I believed in. Right from the start, the media branded the lawsuit as anti-affirmative action. And I have to tell you that that's not something that I thought it would be branded when I was considering and ultimately filed this suit. I had been taught that affirmative action was a policy that was put into place to guarantee that all people were treated without regard to race. In fact, that's what President Kennedy's executive order says about affirmative action. It says we shall treat people without regard to race. And I don't know how somehow that gets flipped on its head to mean treat people with regard to race. Because that's exactly what the University of Michigan was doing at the time. They were treating people with regard to race. Whether they had good intentions or not, that's what they were doing. That's not the original intent of affirmative action. I have to tell you, the first day that I saw the policy that rejected me, it was also a defining moment in this whole campaign, more than a campaign, this whole effort. I had been told about the policy, and I had been told that it was obvious that race was a factor. But the day that I saw it on paper, the policy was actually two separate grids. You had one grid that was for blacks, Hispanics, and Native Americans, and you had one grid that was for everyone else. Whites, Asians, Arabic students, male, female, doesn't matter. And the two grids, they had GPA down one side and test scores along the bottom, and then where your GPA and your test score intersected, that determined if you were accepted or rejected to the University of Michigan. On one of the grids, if you had a 3.0 GPA and a 20, it was either a 20 or a 22 on the ACT. We'll say 22 just to move forward. So a 3.0 GPA and a 22 on the ACT, on one of the grids you were automatically accepted to the University of Michigan. You weren't waitlisted, you weren't rejected, you were automatically accepted to the University of Michigan. On another grid, 3.8 and a 25, you were waitlisted and automatically rejected. On that same grid, the grid that I was placed on, a 4.0 and a 20 on the ACT, versus the 3.0 and 20 or 22 on the ACT. But 4.0, same test score, you're rejected from the University of Michigan. And the grid that had the higher standards was the one that was for whites, Asians, Arabics, so on and so forth. And when I looked at that and saw we're not talking small points here. We're talking full grade point average differences. The fact that the University of Michigan had been doing that for so long and thought it was right, and by the way, defended that policy. They defended that as being perfectly fine, as being race as one of many factors, which we've heard over and over and over again for the past decade. They defended that policy as race as one of many factors. Two separate grids. So when you think about that, and you think about hearing now today that race is one of many factors, that kind of puts it in perspective as to what they could be referring to. taken some criticism for my views, although not near as much criticism as support that I've gotten, whether the support's quiet or very public. I remember the day that my case was being heard at the Sixth Circuit Court of Appeals, and I was walking out of court that day, and there was a big protest going on by a very radical group. And I was with Barbara Gruder, who was the plaintiff in the law school case. As we were walking out, all of a sudden someone screamed at us, "You racist bitch." And I thought, that is exactly the opposite of what I'm fighting for. I'm fighting to make sure that every single individual is judged on their character and their merit, and not their skin color, or for that matter, their sex, even though that wasn't part of the University of Michigan's admissions policy at the time. And throughout the lawsuit, I kept going back to the fact that the media and the elite establishment, the University of Michigan and their administrators, had successfully branded my case as being anti-affirmative action. And I fought that every step of the way. I still to this day do not believe that my lawsuit was against affirmative action. I believe that it was against race preferences, and I think that there is very much a difference. And again, I go back to what President Kennedy said in his executive order. We shall guarantee that all people are treated without regard to race. Somewhere along the line, that got flipped on its head. My case, as you know, went to the U.S. Supreme Court alongside of the case against the law school. And on June 23rd, 2003, the Supreme Court released its decisions. It released the Gruder decision first, the law school decision, and that was a 5-4 decision against us, meaning keeping race preferences in place. And that's exactly what the Supreme Court said in that decision. They did not say that affirmative action would continue. They said race preferences would continue. And it felt like it was about 3 days later before they released my decision, but really it was probably 5 or 10 minutes. And I was watching CNN at the time, and CNN first reported that we had also lost my case. And that was a stunning moment for me to think that the Supreme Court would rule in favor of these types of policies. It later came out that the Supreme Court actually ruled in my favor 6-3. But it gives you an idea of the news commentators and how confused they were on this, because they were speculating that because of the way that the decision came down in the Gruder decision, that it had to come down the same way in Gratz, and they're not going to split this up. It's basically the same, not even basically, it is the same issue. But in fact, that's exactly what they did, was they split this up. One of the positive things, other than the fact that I had won my case, that had come out of the Supreme Court and being at the Supreme Court, was that I met Ward Connerly the day that my case was heard at the U.S. Supreme Court. I had heard of him. He was one of my heroes, but I hadn't met him and hadn't talked with him, hadn't had any interaction with him. And we had met and kept in contact until the decisions came out. And the very day after the decision came out, in both my case and in Gruder, I called Ward. I was in New York City at the time. Was there for media, which again is, coming from a shy girl from Southgate, Michigan, you don't expect to be flying to New York City to appear on the Today Show or 60 Minutes or anything along those lines. But I was in New York City. I'd just finished the Today Show after the decisions came out, and had sat down with Terry Pell, one of my attorneys, and I said, we have to do something about this. And I wasn't focused on the entire decision. What I focused in on was that the Supreme Court had allowed for race preferences to continue, but didn't mandate them. Didn't say that